Thank you, Mr. Chairman. Thanks to all of you for being here. Mr. Leibowitz, I'd like to start with you. I assume you'd agree with me that the federal government is one of limited enumerated powers, correct?
That's correct, Senator Lee.
And to the extent that any one of the enumerated powers granted to Congress is limitless, then the 10th Amendment is meaningless, right? I mean, if Congress can do everything, then there's not much reserved for the states. A few years ago, you wrote a law review article criticizing the Supreme Court's opinion in United States versus Morrison. As you'll know, it's one of only two instances in which the Supreme Court has struck down a statute as being enacted in excess of Congress's authority under the Commerce Clause. It did so based on a conclusion that the activity regulated in that case, acts of violence, were non-economic in nature. They were bare intrastate, non-commercial activity occurring in one state at one time, not part of any interstate commercial transaction, and not part of any channel or instrumentality of interstate commerce. You derided that decision as an instance of conservative judicial activism. You also said that it was a problem. You strongly disagreed with it. Can you tell me if you disagreed with the holding in Morrison and the holding specifically that the Commerce Clause power can't apply to bare, intrastate, non-commercial acts of violence in that instance, what remains beyond Congress's reach under the Commerce Clause?
Senator, I thank you for the question. As you know from the question, let me start with the article. The article was written in 2000. It was written after Morrison and after Lopez. Those were the first two decisions since 1937.
The only two?
Yes, sir. Yes, Senator. The only two since 1937 where the court struck down acts of Congress as beyond the commerce power. Lopez in 1995 was a very important decision because it was the first one, and to supplement what you said, Senator, there were three grounds why they struck down Lopez. There was non-economic activity. There was, does it invade a traditional state function? There was, what are the findings of Congress? Well, in Morrison, so there were three reasons why they struck it down in Lopez. Morrison, viewed by everyone, whether you agreed with the decision or not, really relied on the first one because Congress made explicit findings, voluminous findings in Morrison. The statute itself that was struck down was a civil rights statute, a civil liability statute, not something traditionally reserved to the states. So although you used the word that I criticized with my co-author, Morrison, we really didn't.
Wait, you're saying acts of violence are not historically reserved, covered by state law? I mean, tort law?
Senator, you're certainly correct the way
criminal law?
Yes, Senator, you're certainly correct the way you just stated it. That is state law. But the Violence Against Women Act, the provision that was struck down, was a civil liability provision that was akin to civil rights laws that were passed by this body. Civil rights laws like cases that were upheld in Katzenbach versus McClung and others. My only point, Senator, is that I don't think it's fair to say that my co-author and I were criticizing Morrison. We wrote at a time.
Well, it's generally regarded as criticism when you call it an act of judicial conservative activism. That's not a compliment.
I don't think that phrase is in keeping with the article. What I would agree with you, Senator, in saying is that the Supreme Court in 1995 and the Supreme Court in 2000 started to get more formalist in their categories. And in 2005, after we wrote the article, in Gonzalez versus Raich, the court did not go that far. They did not continue on the path that we were talking about.
Yeah, but Gonzalez versus Raich involved a different category, involved something, exchange of a contraband item for which there's an established interstate commercial market. And therefore it couldn't be regulated adequately absent comprehensive control by national authority. That's very different. By contrast, here's what you said in the article. This is an excerpt from it. Quote, if the court finds that all federal regulations of non-economic activity are equally precluded from the Constitution's limitations on congressional power, then such a decision would so violate social expectations and needs, that it would likely require the court to turn to a different approach in order to define commerce power in a way that's consistent with the four corners of the Constitution and the pressing needs of growing a national and international society. I'm not sure what that means. I'm not sure what provision of the Constitution allows us to modify the terms of the Constitution based on social expectations and needs, or on the pressing needs of a growing national and international society. Moreover, the minute you open up the Commerce Clause to being applicable to bare intrastate non-commercial activity outside the scope of civil rights legislation enacted in 1964, which just as easily could have been defended as an exercise of Section 5 of the 14th Amendment, you're in dangerous territory. NFIB versus Sebelius doesn't count because the court went on to rewrite the law not just once but twice in order to save it from an otherwise inevitable finding of unconstitutionality. I don't understand what your approach is. How would you have written Morrison?
Mr. Chair, if I'm allowed to answer, Senator, if I'm allowed to answer with the time, I appreciate the question. I think I would have said this. There's a lot in your question, Senator. Let me first assure you that there is nothing in that article that should give, I believe, any member of this committee any pause that I will follow the law. If Morrison's the law, I'll follow it.
Yeah, I'm not doubting that. I want to know the answer to my question.
Yes, sir. Yes, sir. So let me take that. And that's why I thought it was important that I said that we wrote it in 2001. After cases like Gonzalez versus Raich in 2005 and others, as you know, part of your question is that the court was seriously considering abandoning, Justice Thomas and others were thinking about abandoning the substantial effects test. That part of the Commerce Clause. I know, just having heard your question, Senator, that the substantial effects test bumps up against the 10th Amendment all the time. What I would say is...
But it swallows the 10th Amendment.
I take your...
But they didn't get rid of that. That's why I'm trying to understand what your analysis is here.
That's right. So what I would say is that after 2005 and other cases, the court has not abandoned the substantial effects test. And if I was so fortunate to be confirmed as a district court judge, I would follow what the Supreme Court and the 11th Circuit say. They allow, in certain cases, when evaluating acts of Congress, to determine whether they substantially affect interstate commerce. That is currently my understanding of the law, and I would follow it. But let me assure you, Senator, I think my background as an assistant United States attorney for 12 years, I think my background just as a lawyer in Miami, I don't think that you should have the, that your question, if it has a concern that I would be some roving judge that would take the commerce power and swallow the 10th Amendment whole, I would respectfully suggest that I would do nothing of the sort.
I get that. I just don't want somebody interpreting the Constitution based on growing societal needs instead of the text of the Constitution. Thank you.
Senator Padilla.
Thank you, Mr. Chair, and greetings to all the nominees today.